Kia ora koutou. Mr Speaker, this bill seeks in essence to give Māori the first right of purchase, the first right of refusal for land that the Crown has acquired compulsorily in the event that the Crown no longer has use for that land, seeks to sell it. And Māori should have that right, at the very least, to have first option of buying back land that was taken through Public Works Act. The Green Party supported this bill to Select Committee because it is a way of addressing a process that has been going on in this country for a very long time, and that is the process of alienation of Māori land. The classic colonising model evolved with the usual, the impact of Bibles and bullets, introduced illnesses played the demoralising part, and then came, starting as early as 1841, a whole raft of legislation, and indeed the Native Land Court, the Public Works Act, as some of these legislative mechanisms that either deliberately or consequentially served to deprive the Māori of their land, of their resources, of their possessions. The Treaty Resource Centre has a very instructive document on their website listing legislative violations of the treaty over the years from 1840 through to about the early mid-1990s. That document runs to some 4 or 5 A4 pages, and it's not a list that should give any cause for celebration or pride to those who are responsible or who have benefited from some of those changes. In fact, quite the contrary. The bill we are considering today is one that seeks to make some contribution to reversing the process and to put in place some provisions that undo some of the harm that has been done over generations. The point's been made that virtually every report, every hearing of the Waitangi Tribunal will contain within it some reference to the effect of the Public Works Act in facilitating the alienation of Māori land, the taking of land from tangata whenua. And in some instances, compensation was not paid for the land at the time that it was taken. And it's interesting to note that in 1908, the Public Works Act first authorised the taking of land by the Crown for public works. And at that time, Europeans had the right to compensation and the right to appeal. But that right was not applied to Māori land until nearly 7 decades later, 1974, before that playing field was evened up. An indication that there was not a lot of great deal of goodwill even through the 20th century to put in right the alienation. The success of the campaign to alienate Māori land can be readily seen in the historic numbers. In 1840, Māori had control of some 66 million acres of land, and within 12 years, by 1852, that had been reduced to some 34 million. Nearly half of the land had been taken by various means. This process went on inexorably, it seemed, well into the 20th and even into the 21st century. In 2004, with the Forshire and Seabird Raupatu, the confiscation of that land. This bill has clearly not been supported by the government, albeit that there is obviously some expression of goodwill to the principle behind it. But in the interest of restoring justice and some of the material wealth lost, it is important that there be a review of the Public Works Act, and we would support the view of the proposer that in the course of the review there ought to be consideration of inserting a treaty clause into the Act. There needs to be acknowledgement of the historic injustice done, and there needs to be some remedies, some mechanisms to remedy those, including solatium payments. And it was quite interesting to note the Land Information New Zealand report to the Select Committee on this matter that dwelt at some length on solatium payments, and clearly officials were quite troubled by the notion, by the principle of these payments. The report noted, and I quote, that solatium payments and loss of use are subjective economic considerations which would require a highly detailed assessment. And the report later goes on to say that potentially the former owner of the land or their successor could be compensated twice. Now, we accept quite happily the first proposition there, the notion of subjectivity. Mana, justice, fairness, these are very subjective notions that do need to be established, debated. Value needs to be assigned to them. But that ought not to frighten us away from the principle of solatium payments at some point in the future. The second, the idea that somehow former owners or their successors would enjoy a double compensation is patently wrong, in fact, the way it is posed in the report, but that is a debate for another day, a topic to be returned to. I think the key assurance that the proposer of the bill should reasonably be expected to secure is a commitment from the government, a genuine commitment, to return to the Primary Act in a timely fashion and to undertake the significant review that is called for. There is clearly goodwill to that. It's been expressed here on all sides of the House, and I would hope that that will not be lost, that review will in fact proceed in a timely fashion. The Greens will continue to support this bill, acknowledging, as we do, that there are significant problems, fishhooks in it, that have been referred to, but we support it to flag the importance of the principle that's underpinning this bill, the return of land, compensation for land inappropriately taken and for which there was no compensation offered. We do think that given the support for the principle that's been expressed by government speakers, but there is now an absolute responsibility on the government to return to this Act and to have that done sooner rather than later. Kia ora koutou.